Items for delivery of government. Item 1, RSA 25 of 2010.
Appeal allowed.
Item number 2, PRTIO 526 of 2025.
Petition dismiss.
Obliged, Lord.
Item 3, RSA 51 of 2026.
Admitted for hearing.
Item numbers 4 and 5, CRPIO 257 of 2026 and CRPIO 258 of 2026.
Both the petition dismiss.
May I please, Lord? In this case, I am challenging order of my lord, not allowing the custody of two vehicles. I am the plaintiff in the original suit, my lord. My two vehicle was hired by the defendant, my lord. The defendant did not
Mr.
pay
Soikia,
my lord.
on the same day,
My lord.
two order was passed by the
Yes, my lord.
trial court.
Yes, my lord. My lord.
By one order, the
Right.
trial court has granted injunction.
Injunction order, my lord.
And by the other order, your petition for custody was rejected
because injunction order, my lord, passed.
because
my
of
lord.
injunction order.
Because injunction. order.
Now
I have
you are
challenged the injunction
challenging
order, my
the
lord.
order by which your application was rejected.
Yes, my lord.
Now, in view of the existing injunction order, can the court grant you the permission?
Yes, my lord.
Grant
That was
you the
challenged, my
custody?
lord. Injunction order, I have challenged by another FAO, my lord, 35/2026, my lord.
Mm.
This matter may be taken with, my lord, that matter, and may be heard along with that matter,
And further, Mr. Soikia,
my lord.
no, this matter is yet to be admitted. How can we direct the registry to list the matter for hearing?
My lord, not hearing, my lord.
Huh?
That matter may be taken with the original, that challenge, my lord, injunction order, FAO 35/2026, my lord. That order may be necessary only, my lord. That was already admitted, my lord. Because this matter related to the original injunction order, my lord.
And you see page number 99.
My lord. My lord. Yes,
Where
my
is
lord.
the complete order? This is not
Yes, my lord.
complete order.
Yes, my lord. Here are some, my, because of my
Or
junior, my
Mr.
lord.
Soikia, learned counsel for the petitioner. It appears from the page number 93,
99.
Annexure Z, that the petitioner has enclosed the impugn order dated 9/3/2026, but the same is not complete
My lord.
order. And in that view of the matter, Mr. Soikia, learned counsel for the petitioner, is directed to bring on record the complete order
My lord.
by filing an affidavit.
My lord.
By filing an affidavit. Mr. Soikia also submits that on the same day, the injunction petition filed by the petitioner, no, filed by the respondent herein was allowed.
My lord.
And the said order dated 9/3/2026 is also being challenged in FAO number
FAO number, my lord, 35/2026, my lord.
35/2026.
My lord.
And as such, he submits that this matter may be taken
My lord.
along with the FAO number so and so.
My lord.
Accordingly, it is provided that registry shall take this CRPIO number so and so with the FAO number so and list the same together.
Obliged.
After registry shall list the matter after 2 weeks.
Item number 8.
Yes, please, your lordship. So the
Hmm.
matter has been heard on the other day to some
Yes.
extent.
But Mr. Kolita,
Lordship.
you tell me, order of attachment was passed on
In the order, it was reflected that lordship order attachment was passed on the back 2022. But
22.
that order has not a valid order, lordship. I have not annexed, but I have the copy of that order, lordship. Lordship may kindly page it.
No. Valid or invalid, that is a different aspect. Whether you have challenged that order.
No, lordship. I am the objector. I have come to the notice of the auction sale only when a order dated 5/6/2020.
No. I am asking you, you answer my query.
No, lordship. But as far as lordship,
Order of attachment was passed on 2nd of June 2022,
22.
right?
No, lordship.
And the transfer sale was made subsequently,
Subsequently, lordship. That is right. But
and the sale deed was registered.
sale is
Whether you have obtained this non-increment certificate,
all I have annexed, lordship. No, in the
how can in view of the attachment order passed by the court, how can you obtain the non-increment certificate?
the court has provided me all that, lordship. I have obtained the form 50.
No.
It has been stated that no litigation has been pending.
How can it be?
That is the question, lordship. But I have
That is the
applied as a
question.
bona fide purchaser. They have provided me
You are
all this,
bona fide purchaser.
because I
You
have
see,
obtained.
In view of the attachment order, the subsequent transfer is illegal.
That is right, lordship. But as per order 21 rule 54 CPC, lordship, it is mandate that all the attachment order. Lordship may kindly page order 21 rule 53, lordship. CPC.
And you say the trial court at page number 114
Yes.
of this petition has observed that the sale of the scheduled land has been effected by playing fraud upon the court.
That has been as per as the learned court below, lordship, that has been committed by judgment debtor, lordship. I am not the judgment debtor. I am the objector, bona fide purchaser. And there is a judgment of the Honorable Supreme Court, lordship, recent judgment.
Maybe.
It was held that under order 21 rule 58, the court shall adjudicate upon all the issues, upon obtaining evidence, if required, lordship.
No. Since your claim itself is illegal, why should the court adjudicate the same?
Because I have no knowledge.
Pending attachment of the suit land, you cannot transfer it.
In a written Supreme Court judgment, lordship.
Forget about Supreme Court judgment.
2025. The Honorable Supreme Court held that.
You say the trial court has also observed that the said Binod Singh, from whom you have purchased the land, has strived to take this court for a right and has engaged in conflicting actions.
That observation is right.
And the court has also observed that the said Binod Singh and the judgment debtor has hoodwinked this court so as to nullify the valid judgment and decree passed in money suit number so and so.
That is right, lordship. There is the observation, but in a petition under order 21 rule 58, court cannot go to this aspect. Only thing the court has to see whether I have righted the interest, and court can summarily dismiss my petition. But if my land has already been sold at the time of presentation of the.
Sorry, Mr. Kolita, we are dismissing the petition with cost of rupees,
my judgment, lordship.
cost of rupees 25,000.
Lordship, may given a time, lordship. I will pay this court, lordship.
Sorry, you are playing fraud upon the court.
But I am.
If you continue to argue, we will increase the I increase the
This
cost.
is right, Lordship, but Lordship may kindly peruse my.
Sorry.
Apply, sir.
May I please, Your Lordship? Lordship, may kindly see the interim order at page, starts from page 109 to page 115. An ex parte order has been passed against us. We are the defendant in a money suit. We filed an application for recalling the ex parte order along with the written statement, along with a prayer to take on
Along with the,
along with a prayer to,
along with the,
along with a prayer to take the written statement on record.
no, the court has observed that you have not enclosed the written statement with the application.
Lordship, that is the main difficulty in this case. On 5/3/2026, we have filed the application as well as the written statement. That written statement also I have enclosed. Page 82 to page 96. 100. Lordship. So that the learned predecessor of the trial court, he orally asked us to take it back, the written statement, and once the application for recalling the ex parte order was to be allowed, that written statement was required to be filed, and that is why it was taken back by the counsel who represented APDC.
Where is the application filed by you?
Page 74 to 81, Lordship. Because at page 77, paragraph number 4, we have categorically mentioned that we have filed the written statement today. That is the day on which date we have filed the application for recalling the ex parte order. But we were asked to take it back, and we were.
Where is the date of this affidavit enclosed with the petition?
Not sure, this is my office copy. So the date is not here. The date is 25th of, sorry, 5 of, 5 of,
From where do I get it?
Lordship, 5th of, that your Lordship will get in the written statement itself. Page 92. It is 5th of March. Because we filed the application.
There is overwriting also.
Yes, that was done by,
Hmm?
they are at Hamren, Lordship.
Done by?
By the counsel who represented APDC and at Hamren.
When the impugned order was passed?
On 26, 2020.
No. Had this written statement was filed before the court, why should the court observe in such a manner
Because
that you have
Lordship,
not enclosed the written statement?
yes, because that was not on record. Because the learned predecessor, he was transferred to DLSA. I have mentioned it. He asked the counsel who represented APDC to file the written statement once the recall application is allowed. And therefore, the counsel who represented APDCL at Hamren, he had taken it back with an expectation that he will file the same once the application is allowed. At page number 5, paragraph number 4, the learned predecessor,
You file a certified copy of the application
not sure,
filed by you before the learned trial court,
not sure,
upon which the impugned order was passed.
not sure,
Heard Mr. Bora, learned counsel for the petition. It is difficult to believe here
not sure.
your contention that the affidavit was filed. No, sorry, the written statement was filed. And you have been asked to take the same back.
That your lordship will not find on record.
You produce the certificate, oh no, sorry, certified copy of the application filed before the learned trial.
Ex parte recall application.
Yes.
Not
Heard
sure.
Mr. Bora, learned counsel for the petitioner. Having heard Mr. Bora, learned counsel for the petitioner, and also going through the record, it is provided that Mr. Bora shall produce a certified copy of the application under Order 9, Rule 7, read with Section 151 CPC, filed before the learned trial court for recalling the order dated 28/1/2026 on next date. List on after 1 week.
Lordship,
Cover.
1 July,
Lordship, obliged,
29 July. 29.
obliged.
Item for orders, item numbers 15 and 16. Started matter.
May it please, your lordship, matter may be passed over for the time being, your lordship. English counsel is on Lex, your lordship. Obliged, sir.
Number 17.
Lordship, it is amended proceeding has been already filed, lordship. Let me come for hearing, lordship. One of the appellant number.
Is it ready for hearing?
Yes, yes.
You are for the respondents.
My senior counsel is not.
That may be fixed.
The timely fixed for.
Appellant number 6 was filed already. First title has been filed already. Nipul Katoni, Nipul Social.
Heard, Mr.
S.J. Sohoria.
Learned counsel for the petitioner, no, appellant, and also heard Mr.
Why Sarkar?
Y.S. Sarkar, learned counsel appearing on behalf of
Respondent 1A, 1B, 1C.
respondent number
1A, B, and C.
1A, 1B, and 1C. The learned counsel for the appellant, referring to the order of this court dated 3rd of June 2026, submits that the appellant has already filed the amended consent. And as such, the matter may be listed for hearing. Accordingly, it is provided that recess list the matter for hearing on
On 13th August.
13th of August.
Item 18.
Simply obliged.
May I please, your lordship, as per office note dated 17/7, no steps have been taken, lordship, in respect of respondents. Kindly 2 weeks time may be granted to take steps, lordship.
Heard, Miss.
B. Hajarika.
Learned counsel for the appellant and Mr.
Yes, this is on behalf of G. Bharadwaj. I am appealing for
Learned counsel appearing on behalf of Mr. G. Vargas. Learned counsel appearing for the respondent number
2 to 5.
225. The learned counsel for the appellant submits that due to inadvertence, step could not be taken upon respondent number 11, 12, 13, 14, and 15, and she plays for granting her 2 weeks time. They are allowed step be taken by speed post and also by usual process within a week from today. Recess is the matter of 4 weeks.
Obliged.
Seven cases, series working. It would go like.
Yon. 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 Two.
No. While mentioning the matter, your senior has not mentioned that there are 27 petitions.
Oh, Yon. Senior told couple of matters, Yon. They're all series matters, connected. Same judgment date, same everything on it.
So why it could not be mentioned at the time of mentioning the matter? That there are 27 matters?
Apologies, Yon. It might have been done inadvertently.
Okay, next slide.
Item 19.
None appears for the petitioner on call. Also, none appears for the respondent on call. Unless the matter after 2 weeks, in the event of subsequent non-representation of the parties, appropriate orders will follow.
Item 20.
No, please, your lordship. Lordship, as per office note dated 17/7/2026, lordship. Notice unable to serve because, well, ward number has not been reflected in the address, lordship. So,
Your Lordship,
Ah.
the last two office notes, respondent number 5 is unserved because of the same reason.
but my lord, respondent number 6 and 7 are the same address line. That notice has been served. But interestingly, respondent number 5 notice has not been served because of the ward number. But 6 and 7 are the similar order, same address.
Maybe you obtain necessary instruction and take a step. of
Yes, sir.
Respondent number 5. Heard, Mr.
M. Das.
Learned counsel for the appellant and also heard, Mr.
R. Ghosh for respondent 1.
Respondent number
1.
Respondent number 1. Office note dated 17/7/2026 indicates that the service report in respect of respondent number 5
5.
receipt and the same indicates that notice could not be served as the address is incomplete,
Income.
that is without ward number.
Word.
Accordingly, learned counsel for the appellant is directed to obtain necessary instruction and to take fresh step upon respondent number 5 within 2 working days from today. Recessal list after 4 weeks shall be taken by speed post and also by usual process. After 4 weeks.
Date may be fixed. my lords.
Yes, sir.
But there is an interim order that may be continuing.
28 August.
28.
Problem.
Sorry, in IA or
Yes, lordship. I.
interim order pass earlier, the IA shall.
21.
Obliged.
Go for the respondent.
Yes, sir.
None appears for the appellant on call. However, Mr.
A. Burwa.
A. Borwa, learned counsel for the respondent present. Place the matter after 2 weeks. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Obliged.
Item 23.
My lord, RSA was dismissed for default during the final hearing stage, my lord. Due to my illness, I went stomach operation. So there is a delay of 101 days. That 2740, my lord. Delay may be condoned and miss case also filed for restoration. It was inadvertent. I was hospitalized.
I have no
I
objection
was-
regarding the delay, Your Lordship. I have no objection regarding the delay, if the delay is condoned. I'm
What
appealing
is
for
the
the,
number of the IA?
2740.
2740. Heard, Mr.
R. Islam.
Learned counsel for the applicant and also heard, Mr.
S. Sharma, on behalf of Mr. S. K. Goswami.
Learned counsel appearing on behalf of
Mr. S. K. Goswami, Your Lordship.
Mr. S. K. Goswami, learned counsel for the opposite party. This application. Under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 101 days in filing the restoration petition for restoring RSN number 150 of 2016, which was dismissed by order dated 3/4/2025 for default. The learned counsel for the applicant submits that on account of his ill health, he could not remain present in the court and file the application for condonation on the application in time. And that the delay is not intentional, rather it is circumstantial, and therefore he is contented to condone the same. The learned counsel for the opposite party submits that he has no objection in the event of allowing this application. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations of shortcoming for the delay, this court is inclined to condemn the delay of 101 days in filing the restoration petition. In terms of above this, I is the exposure.
My lord, regarding restoration petition, case number 38, my lord, my friend has no objection. It might be restored, my lord.
Lordship, regarding that, I have to take instruction from my senior. He is not here right now.
Yeah, I have given it.
I received the copy just now. I've not gone through it.
It may be restored, my lord. I
Let
was-
let him obtain instruction.
Yes, sure.
Heard Mr. R. Islam, learned counsel for the applicant, and also heard Mr. R. Sharma, learned counsel for the opposite party. This application for restoration of RSA number 150 of 2016. Under order 9, rule 8 and 9. Section 151
Okay.
of the Code of Civil Procedure is prepared by the applicant for setting aside order of
I have given the
dismissal
copy, my lord.
for default dated 3/4/2025. The learned counsel appearing for the opposite party submits that he has received a copy today, and he may be granted some time to obtain instruction. They are allowed to list the matter after a week. After a week.
Lordship,
After a
It may
week.
be-
after a week. Lordship, yes. Lordship, in item number 21, I just missed it. There's a, we mentioned it for orders. And it has
Already.
come up and there is interim in that.
No. Interim order is there.
Yes, your lordship. In our favor.
Okay, we'll continue. Later, Mr. Sorenso entered appearance. And praise for extending the interim order. Fair allowed.
I'm grateful.
Item 24.
None appears for the petitioner on call, lays the matter after 2 weeks. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
Item 25.
Lordship, may I kindly pass over the matter for a time being, Lordship. This council is in the legs.
So you were referring for the respondent.
Yes, Your Worship. We have filed our wakalat nomination.
You want to file objection here?
Yes, Your Worship.
Heard, Mr.
Lordship, the deed account behalf of NK Kolita.
Learned counsel appearing on behalf of Mr.
NK Kolita.
NK Kolita, learned counsel for the petitioner, and also heard Miss
S. Chanda on behalf of Mr. S.C. Vishwas.
S. Sandha, learned counsel appearing on behalf of Mr. S.C. Viswas, learned conducting counsel for the respondent. You have filed your Kalanama? Not filed.
Already have filed, Your Worship.
Filed.
Yes.
Okay, learned counsel appearing for the respondent submits that she may be granted some time to file objection in this petition. They are allowed to list the matter after a week. After a week.
Lordship, the stay order is also there. Stay may be continued.
Any date may be given, Lordship.
Interim order shall continue.
I am extremely sorry, my lord. In item 23, there was interim order of stay in the proceeding of court below. Execution case was stayed. I am extremely sorry, my lord. Item 23,
Okay. Okay.
interim order.
Okay.
Item 26.
None appears for the petitioner on call. List the matter after 2 weeks. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
27.
May you please, your lordship, kindly adjourn the matter for 3 weeks, lordship. Here we have to file our objection, lordship.
None appears for the petitioner on call. However, Miss
P. Sharma.
Learned Counsel appearing
I am for
on
the
behalf of
respondent.
Mr.
D. Nandi.
D. Nandi, Learned Conducting Counsel for the respondent. Price for listing the matter after
3 weeks, lordship.
3 weeks, so as to enable them to file objection in this petition. Pair allowed, list the matter after 3 weeks. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Item 28.
May I please, your lordship? You kindly peruse office note dated 16/7/2026, lordship. The unsubmitted notice returned from respondent number 11. And neither AD nor unsubmitted notice from respondent 7, 8, 9, 10, and 12.
You are for
1 to 8, sorry, 6.
1 to 6. Okay. Heard Mr. Borga, Learned Counsel for the petitioner, and Mr. Count for the respondent number 1 to 6. Office note dated 16/7/2026 indicates that notice issued to the respondent number 11 returned with a report within in inverted comma addressee out of station returned to sender. You want to take fresh step upon
On 11, yes.
the Learned Counsel for the petitioner submits that he may be allowed to take fresh step upon respondent number 11. They are allowed. Step be taken by speed post and also by usual process within 2 working days from today. Said office note also indicates that neither ready card nor unserved notice issued to the respondent number 7 to 10 and 12 return till date. List the matter after 4 weeks. Awaiting service report upon respondent number 7 to 10 and 12.
Interim order is
Interim order passed order shall continue.
obliged.
Item 29.
Lordship, I am taking step today for item number 29, 30, 31, my lord.
Part Miss
P. Das, my lord.
Learned Counsel for the petitioner. Miss thus submits that she has taken step upon the respondents today only. Accordingly, it is provided that rest shall list the matter after 4 weeks, awaiting service report upon the respondent. 4 weeks.
30. Item 30. 32.
Say,
30,
32.
May it please, your lordship. Lordship, here I am appearing on behalf of respondent number 1 to 7. I have filed my wakalat nama.
how many respondents are here?
All total, my lord, 12. Others are government, my lord. So they were duly represented, my lord.
Madam, are you appearing for respondent number 8 to 13?
Yes, sir. But our name is not shown in the call list, that's why, lordship.
Okay, but you can enter appearance
Yes,
on
sir.
their behalf. Okay. None appears for the petitioner
and
on call.
13.
However, Mr. Dr. Learned Counsel for the respondent number 1 to 7 present, and also Ms. Borman Learned Additional Government Advocate for the respondent number 8 to 13 present.
No, lordship, this is education department, lordship. Revenue, lordship, there is a separate standing council. And there's a education, lordship, they have also separate standing council. And I'm appearing only for 11 and 13, lordship.
My
You
lord,
are
may
for
kindly
11
see
and
the last
13.
order.
Okay, 11 and 13.
Yes.
11 and 13.
Standing council revenue.
List the matter after 2 weeks. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
My lord, I may be given a opportunity to file my response, my lord.
File your
File my affidavit in objection, my lord, if required, my lord.
Mr. Dotto submits that he may be allowed to file the objection in this petition. Allowed.
And Lordship, a
Obliged.
copy of this CRP, I have Lordship.
Madam petitioner is absent today.
Obliged.
Item 33.
In 33, Lordship, as per direction of the Honorable Court, Lordship, I have communicated the order to the Secretary, Transport Department, but they have, as per their instruction, Lordship, sending that Judicial Department is the Lordship establishment, Lordship, they have look after the entire matter of the transport, Lordship. Transport Department is not a administrative in the Lordship, administrative tribunal, Lordship.
Okay.
In the order to the 25/5/2026, Lordship, or directed the Transport Department to communicate the said order to the entire all over Assam of the Lordship Transport Administrative Tribunal, Lordship. The order is communicated, Lordship. But Lordship, as per instruction, Lordship, the Judicial Department is, Lordship, the necessary part.
Okay. None appears for the petitioner on call. How Ms. Burman, learned government advocate, additional government advocate.
That overall control of the MSCT, Lordship, that the Judicial Department, Lordship.
You were not appearing for any of the respondents.
No, Lordship, I am, government is not a party here, Lordship,
Government is
only
not a
as
party.
per, Lordship.
How Ms. Burman, learned additional government advocate present.
The last
And
order,
produced a
Lordship,
letter dated 12/6/2024 issued by the secretary to the Dr. Assam Transport Department.
In this case, my lord, after in the disposal order, my lord, before this honorable court pass order to submit their order copy, my lord, copy of the order along with the petition, along with the order copy. But the learned counsel who is conducting the case, dear matter in the lower court below, he has, my lord, failed to submit the certificate copy. Only online copy submitted there. That is why 5 November case is fixed, my lord, in the lower court below. 5th of November for compliance of the honorable court's order.
Why this CRP is filed then?
CRP is filed because, my lord, what has happened actually, my lord, in an accident, my lord, wife, husband and son all expired. And parents, my lord, of the daughter, for their married daughter, filed one MSC case, which is pending before the court in this in the city, my lord, Kamrup Metro, my lord. And another case, 3 cases filed by the married sister of the deceased brother, deceased sister-in-law, niece, etc., my lord, in the lower court below in Gwalpara, my lord. So we wanted to implete her as a party, my lord, in our MSC case because we have filed due to the death of our daughter, my lord. The independency of the case, we supposed to file one application, my lord. When we my lord wanted to submit application, my lord, learned court below, my lord, says that you better approach before the honorable high court. That is why with the application we file CRP before the honorable court. After, my lord, disposal of the honorable court, my lord, we supposed to file there in the certificate copy of the order copy, my lord, along with the application, my lord. But learned
What is your pair in this petition?
earlier
CRP.
order.
It is priority.
Whereas to, my lord, my petition may be accept, my lord, to accept the petition in MSC case.
Where is the MP on order?
No order has been passed. That is why. No order has been passed. Just
But
say
then,
that you go there.
If no order has been passed, how can you maintain this petition?
Because, my lord, in this case, my lord, already passed order, my lord, matter has been already disposed of. But only for compliance report that is there.
No, dispose of one.
Hmm?
Dispose
Oh,
of one.
Already, my lord, suppose I have to submit the application again there before the learned court below, my lord, along with the copy of this order. Unless it is accepted, my lord, no order can be passed, my lord. So, my lord, as
So
that
you
is
go
fixed.
and file a
Yes, my
certificate
lord.
copy with one application.
Yes,
then-
yes, my lord, that is fair. So, next date is fixed on
No,
5th of
no,
November.
what order is to be passed in this CRP?
Order has already passed there, my lord,
Where?
in the CRP, my lord. By that order, I have to submit there, my lord. But learned council who is
So
conducting
then
the
why the matter is again listed today?
for compliance of this order of the Honorable High Court.
Honorable, on that, the court has directed the petitioner to file application along with the honor certified copy of this order before the tribunal. But he has filed only certified, not certified copy, only type
Order copy,
computerized copy.
online copy.
So MSCT has not
Fixed the matter.
fixed the matter on November.
5th
for
of November.
Certified copy of this. Today is for compliance, Lordship, of the order.
That is why it is listed before this Honorable Court.
Lordship, kindly go through that order dated 25/5/26. Lordship. Paragraph number 9.
Necessary order.
So now you have to file the certificate copy before
Yes,
the
my lord.
tribunal.
Only online copy, they learned council, the lower court below, my lord, submitted, only file the copy of the order, only online copy. That is why the trouble comes up, my lord. A date is fixed on 5th November.
5th November.
5th November.
On
5th November. 3 months thereafter date will be fixed. 5th of November. So matter may come on, my lord, 13, my lord, November.
this matter.
Yes, my lord. For compliance.
No, whether for compliance of an order
not
you can
necessary,
file on CRP.
No, my lord.
Then
Honorable Court observed that is why, my lord.
you will go and produce the certificate copy
Yes.
there. We close this matter.
Yes,
Why
my lord.
should we keep
That will
the
be
matter
better.
pending?
Yes.
And in fact, this petition itself
Not
appears to be not maintainable.
Yes. Initially, it was not because, my lord, for married daughter parent cannot claim. In this way, there was a move, my lord. Thereafter, I argued the matter. The numbers of judgment placed there. Honorable Court satisfied. Thereafter, passed this order. That is possibly there in the order, madam. I have already placed numbers of judgments.
Mr. H. Das, learned counsel for the petitioner, and also hard Mr. D.D. Burma, learned additional senior government advocate. Person to order dated 25/5/2026, Ms. Das is 41 letter of the Secretary to the Governor of Transport Department. . wherein it is stated that the motor accident claim tribunals are functioning under the Gauhati High Court. Let the letter produced today dated 12/6/2026 be taken to the record. Mr. Das, learned counsel for the petitioner, submits that the petitioner will obtain the certified copy of the order dated 25th of May 2026 and will submit the same before the learned motor accident claim tribunal within a period of 1 week from today.
1 week, 1 week.
1 week from today. And in that view of the matter, this CRP IO number 172 of 2026 stands closed as the order dated effective order upon the CRP IO number so and so was passed on 25th of May 2026. Close the matter.
Obliged, my lord.
Obliged.
Item 34.
Pursuant to the last order, steps were taken through speed post, and in office note dated 6/7/2026, it reflects that unserved notice has been returned in respect of respondent number 1 with a remark addressee left without instructions, and respondent number 2 is awaited, your lordship. Respondent number 1, we have the instruction that he has another address that is also mentioned in the cost title, your lordship, Chennai address. We will take steps on that address as well, your lordship.
Part Mr. Mukherjee, learned counsel for the petitioner. Office note dated 16/7/2026 indicates that unserved notice issued to the notice issued to the respondent number 1 returned with a report addressee left without instruction. And the said office note also indicates that neither AD card nor unserved notice returned issued to the respondent number 2 returned till date. Mr. Mukherjee submits that he will take fresh step upon the respondent number 1 in the address reflected in the alternate address reflected in the petition itself. Step be taken upon respondent number 1 by speed post and also by usual process within 2 working days from today. List the matter after 4 weeks. You want to take fresh step upon respondent number 2?
2 also, your lordship, will take.
Mr. Mukherjee also submits that he may be allowed to take fresh step upon respondent number 2. They are allowed. Step be taken by speed post and also by usual process within 2 working days from today. This is the matter after 4 weeks.
If there is an interim order that will be.
Interim order pass earlier will contain.
Much.
Item 35.
Please, your lordship. I am appearing for the sole respondent, lordship.
Okay. Service completed then.
Service completed. And lordship, I may allow to file an objection regarding the interim order, lordship, passed by this honorable court.
Interim order. Heard, Mr.
GP Boisho.
Learned counsel for the petitioner and also heard Mr.
NH Lashkar.
Learned counsel for the respondent. The learned counsel for the respondent submits that he may be allowed to file objection in this petition against the interim order.
Against interim order. Interim is still returnable today, lordship. Let me continue. Interim order is still returnable today, lordship, next date, lordship.
They are allowed. List the matter after 2 weeks for admission. An interim order passed earlier shall continue till then.
Lordship, we fix the date, lordship.
7th August,
Can it be 11?
10th August, 11 is.
I love.
Item 36.
Please, your lordship. Lordship, service is complete.
Lordship, it is our first appearance and we are for the sole respondent. Lordship, since the service is complete and Wakalatnama is also filed by us, So kindly allow us some time.
Pardon?
Lordship. Lordship, kindly allow us some time. Wakalatnama has been filed.
Sometime for?
Since the senior engaged counsel is not doing well
Okay.
today.
Heard Mr. Kakute, learned counsel for the petitioner, and also heard Miss
N. Kumari on behalf of senior counsel J.
N.
Roy.
Kumari, learned counsel appearing on behalf of Mr.
J. Roy.
J.
J. Roy.
J. Roy, learned conducting counsel for the respondent. The learned counsel for the respondent submits that she may be granted some time in this matter. Where allowed, recessal list the matter for admission after 2 weeks.
Interim may continue, Lordship.
Interim order passerelle shall continue.
Obliged.
Obliged, Lordship.
27.
Your Honor, I am appearing for respondent number 3. We have filed our wakalat number. So 2 weeks time may be given for
Respondent
filing
number?
our affidavit. Respondent number 3.
3. Heard Miss
M. Chetia.
M.
M. Chetia.
Learned counsel for the petitioner and Mr.
J. Kolita.
For the respondent number 3.
3.
3.
Lordship, service report of respondent 1 and 2 may be awaited.
Office note dated 16/7/2026 indicates that neither unserved notice nor ready card in respect of the notice issued to the respondent number 1 and 2 returned till date. List the matter after 2 weeks, awaiting service report upon respondent number 1 and 2.
Well, Lordship, interim order may also continue.
Interim order passerelle shall continue.
38.
Obliged, Your Honor.
Oblige you.
Your Lordship, as per officer dated 16/7/26, service has been awaited upon the respondent, Lordship.
Lordship, I am appearing on behalf of B. Malakar for respondent number 1, 2, and 3.
1, 2, and 3.
3.
And your Lordship, service has been completed. Service has been completed, your Lordship.
4.
4 is minor, Lordship. That will be represented by his guardian, that is respondent number 1, Lordship.
Heard Miss Hazarika, learned counsel for the petitioner and Mr.
A. Hussain on behalf of B. Malakar. Your
A. Hussain, learned counsel appearing on behalf of Mr. B. Malaka, learned conducting counsel for the respondent number 1, 2, and 3. The learned counsel for the petitioner submits that in this matter service is completed, and respondent number 4 submits that respondent number 4 is a minor and is represented by respondent number 1, and as such service is completed and the matter may be listed for admission. Here allowed, recessal list the matter for admission after 2 weeks. Is there any interim order?
No, Lordship.
No.
Lordship,
After 2 weeks.
File number 5 and 9, Lordship.
Yeah.
And the forest, actually forest is also there. This is a forest land.
Respondent number 5 and
9.
5 and 9. And in respect of other respondents,
7 and 8.
6, 7, and 8, Lordship, Forest Department,
Forest
Lordship.
department.
yes,
They have already appeared, Lordship, on last occasion.
appeared.
Yes, Lordship.
Okay, Ms. Beaumont for the respondent number 5 and 9. Now notice for the respondent numbers 6, 7, and 8. 7 and 8. Yes, the learned, however, a learned standing counsel, the learned counsel representing the said respondent entered appearance on 26/6/2026. Place the matter for admission after 2 weeks.
Item 39.
May it please the officer. This IA has been filed seeking leave of the court.
My lord, in this, my lord, I actually prayed for my lord some time to file an objection, my lord. My objection is ready, lordship. But due to this, my lord, summer vacation, I could not file. My lordship may grant me some more days, some time more. Some time, my lord, I file, my lord. It's ready, my lord. Only I have to call the respondent to after 2 weeks. Lord. In the meantime, I'll file the objection in the IA, my lord.
Or Mr. Deka, learned
Sure.
counsel for the applicant, and Mr. Mukherjee. No,
Vijay Ghosh.
Vijay Ghosh for the respondent. Mr. Ghosh submits that his objection is ready
Yes.
and he may be granted. 1 week time?
1 week, 2 weeks, my lord. Lordship, 2 weeks, my lord. I'll 2 weeks, I will file, my lord. Within 2 weeks.
Price for granting 2 weeks time. Pair allowed to recess and raise the matter after 2 weeks.
Obliged.
Obliged.
Item 40.
Please, your lordship.
None appears for the applicant on call. However, Mr.
S. Sen Gupta, appearing for respondent number 3, your lordship.
K. Sen Gupta, learned counsel for the respondent number 3 present. Place the matter after 1 week. In the event of subsequent non-representation of the applicant, appropriate orders will follow.
Obliged.
41.
But in this case, for IA, I have appeared for private respondent, only one respondent, my lord.
Okay.
That's the delay of 52 days, I think. Yeah.
Heard Mr. Paul, learned counsel for the applicant, and also heard
Mr. H. also.
Mr. Sodhuri, learned counsel for the opposite party. Any objection in condonation of
52
delay?
days may be allowed, by. I'm not.
This application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 52 days in filing connected civil revision petition arising out of impugned judgment and order dated 11/9/2025 and the decree passed entitled appeal number 11 of 2019 by the learned civil judge senior division Kamrup Amingam. The learned counsel for the applicant submits that why you could not file the appeal in time?
Due to misplace of my documents, my lord.
That due to
the
misplace
of some documents.
of his document, of some of the case related document, the appeal could not be prepared and filed in time, and that the delay is not intentional, rather same is circumstantial, and the same has been explained in para number.
Number, my lord, lordship, kindly see from the record.
In which paragraph you have explained it? The delay.
3, 4, and 5, may kindly.
Para number 3, 4, and 5. And under such circumstances, he has contended to condone the same. Mr. Sodhuri, learned counsel for the respondent. Oh, no, learned counsel for the opposite party, however, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations so forthcoming for the delay of 52 days in preparing the connected civil revision petition. This court is of the view that the delay is sufficiently explained and accordingly the same stands condemned. In terms of about this, IA stands disposed of, and in view of the IA pass in this interlocutory application, registrar shall proceed to register the civil revision petition and place the same before the court as soon as practical.
I'm extremely sorry, my lord. In item 40, my lord, I could not appear, my lord. My lord, just a date may kindly be fixed, my lord. Obliged, my lord.
Items for admission. Item 10, pardon me. Lordship,
Lordship.
I am facing one problem, my lord. We have left the file in the sender, my lord. Can it be tomorrow, my lord? The brief I have left, my lord, today. He is praying for time being. Can it be tomorrow or, my lord, Wednesday?
Okay. As agreed by learned advocates of both the parties, recess at least the matter tomorrow.
My obliged. Item 11.
May I please, your lordship? Your lordship, finally the matter may be taken up at 2, lordship.
At 2 p.m. it may not be possible. We have one fixed item. The Solicitor General of additional Solicitor General will appear that matter. So at 2 p.m. we perhaps cannot take up this matter.
Then your lordship, a short date may be given, lordship.
Yes, Mr. Madhunda.
Next week.
Next week. As agreed by learned advocates of both the parties, recess and list the matter on public.
Next one, lordship. 31st August. Sorry,
Your lordship,
hearing, they already we get so many hearings.
20,
On 30.
29. Your lordship, interim is there.
Interim order passed shall continue.
Item 13.
Wait, please, Lordship. Lordship, in
Item-
regard to item number 10, can it be fixed on Wednesday?
Wednesday, we agreement. Wednesday.
Item 13.
Here, my lord, disputed land, woodland is described in the plain at Schedule C. Page 109, man. This is a plot of land measuring 18 lassa out of 2 katha 19 lassa covered by dark number so and so belongs to one Hassan Ali. Now your lordship will find in the plain the
Page number 109.
yes,
Schedule number.
schedule number C is there, my lord, the Suitland.
Schedule C is the Suitland.
Yes. Then, my lord, your lordship may come to plain the parties, my lord. Who are the parties here? Page 103.
Yes.
So, my lord, plaintiff is Habibur Rahman, son of late Hassan Ali. And the principal defendant are 1 and 2. 1 and 2, your lordship will find 2 at 5, your lordship may take a 2 at first. Jamina Khatun. Then third line, daughter of Hassan Ali. Daughter of Hassan Ali. So she is a sister of the plaintiff. Then defendant number 1 is daughter of this Jamina Khatun. This defendant number 1 is daughter of defendant number 2. Then your lordship will come 3, 4, 5 are officials. Then next page, pro forma defendant number 6 is another son of late Hassan Ali. Then 7 is another daughter of that Hassan Ali. She has married wife of Yusuf Ali, but she is 7 is daughter of late Hassan Ali. They are the relatives. Then your lordship will come. The
7 is the daughter of
Hassan Ali, the
Where it
original
has been
owner of the land, father of the plaintiff. Hassan Ali, plaintiff, that's why here the plaintiff is one son, one of the elder son of Hassan Ali. Only one.
Habibur Rahman.
Habibur
is the
Rahman.
Son of
Son of Hassan Ali.
Hassan Ali.
Hassan Ali. He is the original. Hassan Ali is
And
the original.
Other respondents are
Jamina Khatun is daughter of Hassan Ali. Defendant number 2. Daughter of Hassan Ali. Then pro forma defendant number 6 is son of Hassan Ali. So 2 brothers now. Pro forma defendant number 6 is son of Hassan Ali. Then pro forma defendant number 7 is again daughter of Hassan Ali. Then 8, defendant number 8, earlier it was Hafizuddin. Then after his death, his legal heirs were implicated in the case. So this is another son of the Hassan Ali, Hafizuddin. Jamila Khatun, wife of Hafizuddin. And so he is another son of Hassan Ali. So there are 3 sons and 2 daughters. Hassan Ali has 3 sons and 2 daughters. Plaintiff is 1 son. Then defendant number 2 is daughter. That pro forma defendant number 6 is son. 7 is again daughter. 8 is again son. Hafizuddin. So this property, which is mentioned at Schedule C, this, my lord, Schedule C land, Schedule C of the plaint, that land is to be divided among the parties, legal heirs of late Hassan Ali. This is the case, my lord. The Schedule C land is to be partitioned or is to be divided.
only 18 lessa of land.
Yes, 18 lassa out of 2 katha 19 lassa. Here the share, how their share has come, my lord. That is the case here, my lord. Now, your lordship may.
So you tell me how many sons and daughters late Hassan Ali?
2 daughters and 3 sons.
Okay.
Sons are 1, 6, and 8. Sons are 1, plaintiff, then defendant, pro forma defendant 6 and 8 are sons. Then 2 and 7, defendant number 2 and 7 are daughters. So now the schedule land, my lord, the page 108. Page 108. My lord, schedule A land. A plot of land measuring 3 kata 9 lassa, where Hassan Ali was the owner. 3 kata 9 lassa land, Hassan Ali was the original owner.
So Schedule C land is a part of Schedule A land.
Schedule A land.
Okay.
Yes, my lord. Then Schedule B land, my lord, is a plot of land measuring 10 lassa out of that 3 kata 9 lassa. This 10 lassa land, in the plaint or the plaintiff has prayed that this land has been gifted by his father during his lifetime. Schedule B land, 10 lassa land.
Gifted to?
Gifted to plaintiff. by Hassan Ali during his lifetime. This 10 lasa land. Now here, the defendant while filing written statement, defendant defendant number 2 has claimed that this land was also gifted to defendant number 2, Schedule B land. In the plaint, he has prayed for this land as
According to you, Schedule C land is the suit land.
is the gifted land of the plaintiff. It's a gifted land gifted by Hassan Ali to the plaintiff. Now, in written statement and counterclaim filed by defendant number 1 and 2, they have also said that this Schedule B land actually was gifted to defendant number 2 by Hassan Ali during his lifetime. This is the case, my lord. Now, your lordship, for this, my lord, the matter has been, my lord, this made critical. While Schedule D land, your lordship will find Schedule D land, next page, my lord, 109. A registered sale deed was executed by defendant number 2 in favor of defendant number 1, selling this Schedule C land in favor of defendant number 1. This Schedule D is a registered sale deed executed by defendant number 2, who is one of the daughter of Hassan Ali. This land she has sold to defendant number 1, that is defendant number 1 is daughter of defendant number 2 in their relation, my lord. The defendant number 1 is the daughter of defendant number 2. So this is the case. So now I'll take your lordship to the judgment of trial court, and the point of consideration
That page number?
Yes, but I'm coming. Now, page number 82. There is the point of consideration. Now, issue number 6, whether the defendant oblique counterclaimant has been in possession of land described in Schedule B of the plaint. If we go through it, then the things will be clear to us. Schedule B land, that gifted land by Hassan Ali to the plaintiff. Page 83, man. Yes, married, man. It has been admitted by both the plaintiff and the principal defendants that late Hassan Ali was the original owner of a land measuring 3 kata 9 lasa covered by dag number 92 and patta number 107, which is mentioned as Schedule A in the plaint and the counterclaim. The counterclaimant alleged that during the old age of Hassan Ali, she being...
Mr. Sinha.
Yes, madam.
We are concerned with Schedule C land.
Yes.
You are reading this
Yes,
issue number 6.
Yes. If we don't go through issue number 6, the things will not be clear, madam. That's why I'm going there first. Then we will come to that later, madam. The counterclaimant alleged that during the old age of Hassan Ali, she being his daughter was the only caretaker of Hassan Ali. As such, out of love and affection, Hassan Ali verbally gifted 10 lasas of land out of 3 kata 9 lasa in presence of villagers, Maqbul Hussain and Abdul Khalik. This portion of land is marked as Schedule B in the plaint and the counterclaim. There, my lord, the counterclaimant defendant number 2 asserted that after the death of Hassan Ali in 1995, she had been in possession of Schedule B land by constructing dwelling house. Thereafter, defendant number 2 sold 18 lasas of land to the defendant number 1, which is marked as Schedule C in the plaint and in the counterclaim, including Schedule B land in 2013. And since then, defendant number 1 has been in possession of Schedule B land. It is alleged that plaintiff wrongfully entered into the land of defendant number 1 on 308-2014, and hence the defendant number 1 filed MR case number so and so before the Deputy Commissioner, which is pending. In this regard, in the plaint and the written statement against the counterclaim, the plaintiff stated that Schedule B land was verbally gifted to him by Hassan Ali in presence of her family members and villagers A. Nobi, Joinal Uddin. Accordingly, the plaintiff has been in possession of Schedule B land since 1995. Both the plaintiff and the counterclaimant stated that Schedule B land was gifted by Hassan Ali verbally. Hence, there is no documentary proof of the alleged gift to show whether it was gifted to the plaintiff or to the counterclaimant. During examination of DW1, Ramisa Khatun stated that Hassan Ali gifted 10 lasas of land to her mother Jamina Khatun. Yes. 10 lasas of land to her mother Jamina Khatun. Regarding possession of land, it was suggested by plaintiff during cross-examination of DW1 that after execution of registered sale deed number so and so, when she went to take possession of the land, the plaintiff intervened, and as such various cases were filed among the parties. During cross-examination, DW2 Maqbul Hussain stated that Jamina Khatun obtained 7 lasas of land from Hassan Ali and has been staying on the land constructing dwelling house along with her daughter Ramisa Khatun and son-in-law. DW2 expressed his ignorance regarding other facts of the suit. Thus, defendant number 1 neither adduced any documentary evidence nor any oral evidence to prove the factum of gift by Hassan Ali to her mother Jamina Khatun. To prove the gift, Jamina Khatun would have been the best evidence in favor of the defendant, but in spite of the fact that Jamina Khatun filed written statement against the plaintiff, she was not adduced to depose and prove her statements made in the written statement. On the other hand, plaintiff adduced 4 witnesses, all of whom consistently stated that Schedule B land was gifted by Hassan Ali to the plaintiff. During cross-examination as PW1, the plaintiff denied that Hassan Ali was taken care by Jamina Khatun during his old age, and as such, Hassan Ali, out of love and affection, gifted Schedule B land to Jamina Khatun. PW2 Amina Khatun, during her cross-examination, deposed that Hassan Ali had gifted 10 lasas of land to Habibur, that is plaintiff. The plaintiff, PW3 Ayatullah, during his cross-examination, denied that Hassan Ali gifted 10 lasas of land to Jamina Khatun. PW4 Joinal Uddin, during cross-examination, deposed that out of disputed 18 lasas of land, only 7 lasas of land has been in possession of Jamina Khatun, and rest of the land has been in possession of plaintiff. He denied that Hassan Ali gifted any land to Jamina Khatun, and also denied that Jamina Khatun had been in possession of 18 lasas of land. He confirmed that Hassan Ali gifted 10 lasas of land to Habibur Rahman, means plaintiff. From the above, it is revealed that there is no documentary proof of the oral gift made by Hassan Ali as to whether it was gifted to the plaintiff or defendant number 2. The defendant number 2 failed to adduce any documentary or oral evidence to prove the gift in her favor. In the written statement, defendant claimed that out of love and affection, Hassan Ali gifted Schedule B land to Jamina Khatun as she was the only caretaker of Hassan Ali in old age. However, during cross-examination PW3, it was suggested to the witness by the defendants that as Hassan Ali has not given any property to Jamina Khatun during her marriage, he gave a share of altogether 18 lakhs of land. Hence, the stand of defendant is contradictory. In the written statement come counterclaim, the defendant state that Hassan Ali gifted the Schedule B land to Jamina Khatun in presence of Maqbul Hussain and some villagers. However, Maqbul Hussain during his cross-examination clearly denied that Jamina Khatun was gifted any land by Hassan Ali. Further, the defendant, while describing Schedule B in her written statement, some counterclaim stated in writing that Schedule B land was obtained by plaintiff by an oral gift. All the plaintiff's witnesses PW1, PW2, PW3, and PW4 consistently stated that the Schedule B land was gifted by late Hassan Ali to the plaintiff, and since the year 1995, he has been in possession of Schedule B land. Hence, the claimant is failed to prove her possession over Schedule B land. Rather, it is proved that land was gifted to plaintiff by Hassan Ali, and the plaintiff has been in possession of the land. Therefore, the issue number 6 decided in negative and against the counterclaimant. So, my lord, that Schedule B land, the trial court has decided it is gifted in favor of the plaintiff. Then, my lord, in respect of this Schedule C land, issue number 4, 5, and 7 is to be, my lord, read with me. In the 82 point of consideration, issue number 7, whether defendant counterclaimant has any right, title, and interest over Schedule C land. Page 82, issue number 7, whether the defendant counterclaim has any right, title, and interest over Schedule C land described in the plain. And 4 and 5 is whether plaintiff has any right, title, or interest. And 5 is whether sale deed executed by so and so is valid or invalid. So, if we read this issue, my lord, page 85, 4, 5, and 7. May I read, my lord?
Yes.
A plot of land measuring 18 lasas out of 3 kata 9 lasa is marked as Schedule C, which has been sold by defendant number 2 Jamina Khatun to the defendant number Ramisa Khatun by registered sale deed number so and so. It has been admitted that Hassan Ali was the original owner of 3 kata 19 lasas of land covered by Dag number 92 and Patta number so and so. As discussed above, it was proved out of balance of probabilities that 10 lasas of land out of 3 kata 9 lasa gifted by Hassan Ali to the plaintiff. It is also admitted that remaining 2 kata 19 lasas of land was divided in accordance with Muslim law among the legal heirs of Hassan Ali. Accordingly, each of 3 sons, Hafizuddin, Habibur Rahman, and Abdul Salam, that is plaintiff, then pro forma defendant number 6 and pro forma defendant number 8, got 14 lasas of land, and each of daughters, Jamina Khatun and Amina Khatun, this is defendant number 2 and defendant number 7, got 7 lasas of land. The plaintiff claimed that Amina Khatun have relinquished her share. This is important, my lord. The plaintiff claimed that Amina Khatun have relinquished her share of land and given the same to the plaintiff, and accordingly plaintiff has been possessing his share along with share of Amina Khatun. Then, my lord, thus out of Schedule C land, the plaintiff has been in possession of 11 lasas of land. As such, he claimed that defendant number 2, Jamina Khatun, had no saleable.
Mr. Sinha.
Yes, my lord.
We will continue after 5 minutes.
Yes, my lord.
My lord, my item was item number 27. So against party had taken a time for filing objection affidavit, my lord. I have no objection to that. Only thing was that there was a interim order, my lord. That interim had to continue, my lord.
Okay, item number 27.
That interim may continue, my lord. Must be.
Lordship, kindly possibly the matter for today, Lordship, item 43.
Item number
43, Lordship. That is fixed for hearing today, Lordship.
43 is especially fixed by the eviction matter, my lord. 21, my lord. Rent control.
We have not called the matter.
My lord, yes, but she's mentioning, my lord, that is right.
You are mentioning.
When do you want?
Lordship, kindly adjournment, sir, Lordship.
When?
Lordship, due to some personal difficulties of.
No,
my
that's all
family.
right. When can it be listed?
Oh,
Next week,
Lordship,
maybe fix, my
next
lord, in
week.
that case, my lord.
Next
Because
week.
Next week.
they should have informed in advance, my lord, so that I.
Yes.
Lordship, due to traffic, we could not reach on time.
Okay. Come in next week.
Twenty-eight. 28. my lord.
Okay. As agreed by learned advocate for both the parties, let's just list the matter on 28. Okay.
Obliged, Lordship.
Mr. Sina?
Yes, ma'am.
And Abdul Salam got 14 lakhs of land. Each of daughters, Jamina Khatun and Amina Khatun got 7 lakhs of land. The plaintiff claimed that Amina Khatun have relinquished her share of land and given the same to the plaintiff, and accordingly plaintiff has been possessing his share along with share of Amina Khatun. Thus, out of Schedule C land, the plaintiff has been in possession of 11 lakhs of land. As such, he claimed that defendant number 2, Jamina Khatun, had no saleable right over 18 lakhs of land described as Schedule C land in the plaint and the counterclaim. The remaining 7 lakhs of land is the share of defendant number 2 out of Schedule C land. The plaintiff stated that sale deed executed by defendant number 2 bearing number so and so is illegal and null and void. In this regard, by written statement and counterclaim, the defendant number 1 and 2 along with pro forma defendant number 1 to 85 stated that after partition of the land among the legal heirs of Hassan Ali, Amina Khatun relinquished her share to her brothers and sisters, and accordingly the share of Amina Khatun of 7 lakhs of land was equally divided among 3 brothers, each getting 2 lakhs, and Jamina Khatun got 1 lakh of land. Jamina Khatun claimed that Hassan Ali gifted 10 lakhs of land out of 3 katas 9 lakhs. Thus, according to Jamina Khatun, she got 10 lakhs plus 7 lakhs plus 1 lakh equal to 18 lakhs of land, which has been sold by her to her daughter Ramsha Khatun, defendant number 1, by registered senior so and so. As already had been discussed above, Jamina Khatun could not prove the fact that Hassan Ali gifted 10 lakhs of land to her, and she also could not prove that she had been in possession of the land gifted by Hassan Ali. During cross-examination, DW1 stated that she did not know if the share of Amina Khatun was given to the plaintiff by Amina Khatun or not. Here, the best witness to prove the fact whether Amina Khatun gave her share to the plaintiff or not is Amina Khatun herself. Amina Khatun was examined as PW2 by the plaintiff, who during her evidence in chief stated that she relinquished her share of 7 lakhs of land to the plaintiff. The defendants during her cross-examination could not assail the credit of witness in this regard. The defendant even did not put any suggestion to the witness in respect of this fact. Further, during cross-examination, DW2, the only independent witness adduced by the defendant, stated that Jamina Khatun had been possessing only land measuring 7 lakhs, which was her actual share of constructing house thereon. Thus, the evidence in the record reveals that defendant's counterclaim have been in possession of only her defendant number 2 share of 7 lakhs of land. The remaining 11 lakhs of land has been in possession of the plaintiff. Further, one of the defendant counterclaims, Jamina Khatun, was the best evidence to prove the claims of counterclaim, but the counterclaimant did not adduce her evidence, and so the benefit of non-examination of best possible and available witness goes in favor of the plaintiff. Hence, it is held that defendant number 2 had no saleable rights over entire Schedule C land of the plaintiff, and the counterclaim. I have also perused the judgment adduced by the plaintiff passed by so and so, so and so, so and so.
Mr. Sinha,
Where, yes, ma'am.
Mr. Sinha, the counterclaim and do file, no evidence was adduced.
Yes, my lord. Means, my lord, Schedule C land, after giving, after my lord, parting this 10 lasas of land from the total land, that is there are 2 katha 19 lasa.
No, that Schedule C land was the part of the part of Amina Khatun's land.
Is Amina Khatun's land.
That land was relinquished.
Relinquished to
by
plaintiff.
her in favor of the plaintiff.
Plaintiff. 7 days.
Okay.
As per their the division, my lord, that each brother got 14 lasas and daughters got 7 lasas. So, my lord, this Schedule C land, 18 lasas, defendant number 2 has the share of 7 lasas land only. Even 11 lasas actually she does not have. As per this judgment. Therefore, my lord, the 7 lasas, the defendant number 2 can sell only the land, 7 lasas of land, not extra land, which she has stated that this 10 lasas of land has been given on gift by her father. Then another 1 lasas of land is Amina Khatun's land, which is relinquished to the plaintiff. There also something is there. Actually, the 7 lasas of land is to be divided among brother and sister. But this is not the case here. Here, 7 lasas of land has been totally given to the plaintiff. Therefore, plaintiff has got land, his share, that is 14 lasa, out of this 2 katha 19 lasa, my lord. 14 lasas, then plus again 7 lasas, which is 21 lasa, my lord. See, the plaintiff is possessing. Now, we, as per this thing, the sale deed was for 18 lasas, whereas 11 lasas of land is not under their possession, or it is not in their share also, my lord. So, my lord, the honorable court, this is the fact, my lord. So, my lord, here Amina Khatun land, 7 lasas land, which has been relinquished. Whether this second appeal, whether deed of relinquish is required or not, in the entire, my lord, suit, my lord, no such deed of relinquishment has been executed or evidence, my lord, adduced, my lord.
No, maybe, but whether there was in fact the relinquishment deed or not.
Yeah, this is my substantial question of law, my lord. Whether relinquishment land of Amina Khatun without, my lord, this deed of relinquishment is maintainable. This is one of the substantial question of law. Then other thing is that, but this is the fact of the case, my lord. So trial court has come in the, my lord, while disposing the.
Mr. Sinha, you see, Amina Khatun examined herself as witness. No, PW1 has plaintiff has examined Amina Khatun as witness.
Yes.
She has deposed that she has relinquished.
She has relinquished her share.
Yes.
Yes, of course, ma'am. Of course,
Whether in that view of the matter, the relinquishment deed is required.
That is to be examined, my lord. That is to be examined, my lord. That is to be examined, my lord. Whether just by verbally, orally saying.
No, you say.
Gift is all right. Oral gift is, my lord.
Can
be, but relinquishing her right, whether any writings, my lord, just saying verbally, whether it is, this to be examined.
So, trial court has
accepted, man.
Accepted. And appellate court has also accepted.
No, there is the peculiarities is there. That's why I come to the order part, my lord. Now, order part you also will find page 88. Page 88, man. From the above discussion and the decision reached the aforesaid issues, it has in a suit of the plaintiff is decreed partially. That is, as per plaintiff, the prayer of the suit is that plaintiff has prayed decree for Schedule C land. Schedule C land. Partially on the contest with cost, and the plaintiff is not entitled. Right, title, and interest over Schedule land of the plaintiff and the registered sale deed number shown is null and void of the land beyond the share of the defendant number 2. That is the Schedule C land is a 18 lasas of land where defendant number 2 has her share. Now plaintiff in her plaint prayed that entire Schedule C land to be decreed in his favor. So that's why my trial court after examining all these things dismiss allowed the suit partially, that different number 2 has his right of share there over the Schedule C land. So that's why, my lord, partially decreed the suit, leaving aside the land of different number 2. Decreed partially on contest with the cost, and plaintiff is not entitled right title interest of the schedule land of the land and registered sale deed number so and so, index so and so, beyond the share of different number 2. So schedule C land has been partially decreed as per this.
What is the quantum of the Schedule C land?
18 lassa.
18 lassa. And out of 18 lassa, 7 lassa.
7
belongs to-
other than 7 lassa, 11 lassas land has been decreed. As per the meanings come there. So now
11 lassa or 7 lassa?
11 lassa of in favor of plaintiff, partially decreed. Out of 18 lassa, 7 lassa if we minus, my lord. If we subtract 7 lassa, then remaining is
No. Amina Khatun has relinquished her claim in respect of her share. Her share means her share is
7
7
lassa.
lassa. So plaintiff is entitled to that 7 lassa.
Oh yes, that he will get. The land relinquished by Amina Khatun if 7 lassa.
Yeah.
And exactly at the same time, Jamila Khatun, there is the different number 2. She also got share of 7 lassa land. That which has been while selling the land, it is increased by 11 lassa more. 7 plus 10 lassa, sorry, 11, 8, she has made 18 lassa. Means 7, her share is 7 lassa. Then 10 lassa she has taken that, she has thought that 10 lassa is gifted to her. And 1 lassa she has taken from Amina Khatun, which has been relinquished land. 7 lassas of land, as per the court has discussed here, trial court has discussed, if it is distributed to all of the brother and sisters, that Amina Khatun's land, then brothers will get 2 lassas and sisters will get 1 lassa. That is also not correct. Here is not the inheritance. It is that dividing the land of 7 lassa.
It is their family settlement.
Yeah, family settlement. So 2 lassa, then 3 brothers, 7 lassas of 3 brothers, different plaintiff, then different number 7, 6, and different number 8. 3 brothers, 2 is 6, then remaining 1. The 1 landa that different number 2 has thought that 1 lassa has come to me.
No, trial court has dismissed the counterclaim.
Yeah, counterclaim
And
dismissed.
decreed the suit partially.
Partially.
And Schedule C land was not given to him.
No. Yes, leaving aside the land of different number 2, her share.
So the language is not so clear.
Yeah, language is not clear, my lord. Now again, this one, this my lord, this observation has been against, my lord, rejected by appellate court. Appellate court also very, my lord, in other way, my lord. So now I will take your lordship to the court of appellate judgment.
Okay.
In appeal, counterclaim also made an appeal. Then plaintiff has also made an appeal. So in appeal, there are 2 appeal, my lord. Now, page
No,
24, my lord,
whether,
para 38.
Whether both the appeal are disposed of by the same order?
Same court, same court,
No, no, same order, same judgment or different judgment?
different judgment. Different judgment in the same, by the same court from the same trial court judgment.
No, that's all right.
Yes, two appeal. One is plaintiff has filed an appeal. Then to counterclaim also, defendant also, they have filed an appeal.
So now you tell me what is the outcome of the appeal filed by the plaintiff?
Plaintiff modified, my lord. That is your lordship will
Final
find
appeal number 7. That
Seven.
is the plaintiff appeal.
plaintiff appeal.
Where is the operative part?
Yes, my lord. My lord, that page 32, my lord.
Yes, it was allowed with cost.
Yes,
It is
in the
declared
result,
that
the
plaintiff
instant
has
appeal of the
joint
plaintiff
right
is hereby
and
allowed
interest
partly with cost. Then it is declared that the plaintiff has joined, that is the appellate court has added, joined right, title, and interest over schedule and along with other legal heirs of Hassan Ali. So he has modified, my lord. The disputed land is C-schedule land, 18 lakhs of land. Then 18 lakhs of land, appellate court has decided in his appeal that it is declared that plaintiff has a joint right, title and interest over C-schedule land. That is 18 lakhs of land, where defendant number 2 has also shared. So he has said that joint right. And for this joint right, the trial court has partly allowed the suit, decreed. Then others are okay. Sale deed has been made null and void. Then your lordship may come to the my lord.
No, it means that all the
Shares.
sons and daughters
Yes.
of the
Have a joint right.
Hassan Ali, late
Yeah.
Hassan Ali, has their right over the
Over
ceded
the
seal.
C-schedule land. That is my lord. Now in the counterclaim also, my lord, your lordship may come.
No, other brothers and sisters have not claimed their right over scheduled C land.
Yes, and only plaintiff.
Only plaintiff and in counterclaim, the
Yes, my lord. Yes.
Defendant number 2.
Defendant number 2.
Others have not claimed
Others have not
title
come.
and interest.
Others have not come.
That's why the court has granted, appellate court has granted their right, title and interest.
For all.
All. Okay. And where is the other appeal?
Yes, counterclaim page 65. My lord. Page 65. In the result, the instant title appeal of the defendant number 2 counterclaim is hereby allowed partly with cost. It is declared that defendant number 2 counterclaimant has joint right, title, and interest over C-schedule land.
Okay.
That is the thing. So, my lord,
And what are the substantial question of law?
substantial question law, my lord, page 7, my lord. B, my lord, B. Page 7B. Whether the impugned judgment and decree passed by the first appellate court is justified in declaring the suit then described in Schedule C of the plaint jointly along with others. Then if we go by the prayer of plaint of the plaintiff, then C also, my lord, we can add under substantial question of law.
These are the grounds. So where is the substantial question of law?
This is the matter. B and C. B and C.
These are the grounds.
Man, I have not extra. I have what I have here also. For this, I have directly printed, my lord, typed out, my lord. For that, the substantial question of law arises as to whether the impugned judgment and decree passed by first appellate court is justified in declaring the suit land so and so so and so. And C, whether the
What is page number 8A?
Page number. No other extra page I have, my lord, added, my lord. Extra substantial question I have not brought, my lord. If my lord requires, my lord, I will do it, my lord.
No, no. You have enclosed it as page number 8A,
Page number 8, my lord.
8A, capital A.
Oh, sorry. Oh, sorry. Oh, I have missed it, my lord, sorry. I don't
But,
have, I think there is a question of.
Mr. Sinha,
Yes,
you
my
see,
lord.
this, as per subsection 3 to section 100, this substantial question of law has to be incorporated in the memo of appeal.
Memo of appeal. The 8A is memo of appeal.
8A is tagged with the memo of appeal. It is not part of the memo of appeal.
Oh, then I have to do, my lord. I'll do it, my lord.
So anyway, which substantial question of law is relevant here now?
B and C, my lord.
B and C. Whether the trial court has a frame point for determination in the viewing judgment and decree passed by the first.
Yes, sir. At page 82, my lord.
82.
Yes.
No, 82 are the issues framed by the
Yes, my lord.
trial court.
Yes, my lord.
No, whether the first appellate court has
Yes.
formulated any point for determining.
Yes, my lord. Yes. My lord, page 22.
Okay, only one.
Yes.
Where is the issue number 7? That has not been discussed.
Issue number by the appellate court.
Yes.
That thing discuss, I think.
You start it from page number. Title appeal number 7 of 2019.
Yes, madam.
Issue number 1 is at page number 20.
Yes, 3, 4.
Then issue number 2 at
Yes,
page
ma'am.
number 23.
Yes, madam.
3 and 4 at page number 24.
Right, madam, right. Issue number. Yes, issue number 7 not discussed.
Issue number 5 is at page number 30.
Yes, madam.
And 8, 10 and 11 at
Yes,
page
7
number
left out,
31.
madam.
7 is not there. That is the main issue, in
Yes,
fact.
yes, madam.
So, that provision. Order 41, rule 31.
Yes.
So appellate court judgment has to formulate the point for determination and thereafter to assert as a. The trial court has, no, appellate court has framed only one point, formulate only one point for determination. And the issue number 7 has not been discussed there. The judgment in counterclaim has not been challenged.
Not been challenged. Even
No,
judgment
yeah.
judgment of title appeal also, my lord, just I have come. He did not come. Plaintiff did not come. Plaintiff also did not come.
Then who preferred this appeal?
But the defendant number 1.
Defendant number 1.
Yes. Daughter of defendant number 2, counterclaimant. Defendant number 1 also counterclaimant.
It's a peculiar case. So here, which judgment you are challenging? The in title appeal number 7 of 2019 or 3 of 2019?
My lord, actually, when as per that, I have to come against my petition, that is counterclaim.
No, this appeal is preferred by Habibur Rahman.
No.
You come to page number 2.
My lord, this is title appeal, it is title appeal number 7/19. Now, 2 appeals are there, so this has been included in the cost title. Now, if your lordship comes to the page number 6, he's the appellant. Ramisa Begum, who's the defendant number 1.
Romisa Khatun.
Yes, my lord. Who's the defendant number 1?
Appellant. Okay. Here, she challenged both the appeal. No, the judgment and decree passed by the appellate court in the title appeal number 7 and also title appeal number 3. Right? And you say in one of the appeal, the issue number 7 has not been discussed in 7. Title appeal number 7. Then one substantial question of law would be whether the
Yes, my lord. First appellate court is justified, my lord. This,
no, that whether the judgment of the learned first appellate court in title appeal number 7 of 2019 suffers from perversity for not directing any discussion in respect of issue number 7 and recording a finding and for non-recording a finding in that regard. You do one thing, you submit the substantial question of
Yes,
law.
you
file amended cost title.
Yes,
You
yes,
incorporate the substantial question of law before the certificate.
yes.
Part start. Be seen a learned counsel for the appellant. List the matter on 1 week.
Monday and Tuesday I will be absent, my lord. Wednesday or Thursday next week.
Wednesday then?
20?
Wednesday?
Wednesday open.
Friday.
How?
31st. 31st of
July.
31st of July. And in the meantime, Mr. Sinha, learned counsel for the appellant, shall file amended memo of appeal incorporating the suggested substantial question of law. So on that day, we'll frame the question of law.
Obliged.
Item 14.
Maybe his lordship. Maybe his lordship. The appellant here is the original defendant in the title suit, lordship.
Yes.
The plaintiff has filed a suit for cancellation of mutation and declaration of right title interest against the defendant. And what happened in this case, lordship? Though defendant has filed their written statement, but after the retirement of their engaged counsel in the trial court, the defendant did not contest the matter. So matter was proceeded ex parte. And the interim judgment, lordship, the trial court at page 24. And operative person, I am reading lordship at page 26. Second line, it is pertinent to mention here that second lordship, it is pertinent to mention here that initially the defendant number one contested the suit by filing written statement. Accordingly, issues were also framed on so and so, but from the order dated 11/7/27, it appears that the defendant failed to cross-examine the plaintiff witness and also failed to adduce any evidence in the support of their written statement, allowed the suit to be proceeded uncontested. Hence, in view of the above facts and circumstances, due to the non-adducing of evidence by the defendant side, the amendment made in the written statement are not taken into consideration. As the suit proceeded uncontested, the issues framed on the basis of the written statement filed by the defendant are also not taken into consideration. This is the ending of the trial court, and it was upheld by the first appellate court. That's So in the first appeal, Your Lordship,
Where is the plaint?
in just page 10.
Is then.
Yes. So plaintiff claimed that it was booked by his father in 1973.
Gifted by her father.
His father. So this defendant number one and the predecessor
there are
plaintiff
two
are the
plaintiffs.
brothers.
There are two plaintiffs.
There are three numbers of plaintiff. The
Pardon?
three numbers of plaintiff.
No, page number 10. There are two plaintiffs. Oh, okay. Diganto Sikya.
Yes. Sonalata, Simanto, and Diganto. They are the plaintiff. The predecessor of the plaintiff and the defendant number one are the brothers.
Okay. The trial court has decreed the suit.
Decreed the suit.
And appellate court has affirmed the same.
Yes. It's it. And Lordship, apart from it, the findings that they have no position, the plaintiff have no position. Admittedly, in plaint also, they have said that they have no position. So without their position, the learned trial court has decreed in their favor for permanent injunction, not to disturb their position.
Originally, the land was annual patta land.
Annual patta land.
It was converted to
It was
periodic
converted
patta.
into, yes, periodic patta. During the, when the land was annual patta land, gift was alleged to
Annual
be
patta
executed.
land
That
was issued to the father of the
it is the issue to the father of the plaintiff and
as well as the
defendant
defendant.
number one.
Yes.
Yes.
So when the land was converted from annual patta land to periodic patta land,
Periodic patta.
when?
It is after the date of in the year 1975.
1975.
1975. Yet I'm referring page 12, para 4 of the plain. Eventually, a new patta being numbered on so and so was made out, and while making the said new patta, the district revenue code recorded the names of all the 3 sons of the original owner, that Loknath Soika, herein without giving any effect to the deed of gift as referred to the herein before. So Loknath Soika died in the year 1975.
The land was converted from periodic on an annual patta to periodic patta in the year 2000, 1975.
75.
And the gift deed was
In 1973.
1973.
73.
So as per land revenue regulation, the annual patta land cannot be transferred or alienated. And when the father died?
Father died in the year 1975.
Before conversion or after conversion?
It was not reflected in the plain, Lordship.
Not reflected.
Not reflected. But land was converted in the name of all the 3 sons of the original owner, Loknath Soika. That this present plaintiff claiming that their predecessor has obtained the gift deed in 1973. So they came before the Honorable Court for cancellation of the mutation of the
Whether that gift deed was a registered gift deed?
registered gift deed, Lordship. As they claim, but we have denied their gift. We challenge their gift deeds, Your Lordship, says that this is a fabricated document. So how that is we have mentioned in our WS at para 9.
Maybe, but you have not adduced any evidence.
Lordship.
Then
that is true, Lordship. So after the death of, after the retirement of the engaged counsel, so defendant did not take part in the proceeding further.
Then?
So that is the result, Lordship.
So the gift deed prepared in the year 1973 remain unchallenged.
Unchallenged, but
then
gift deed produced
on
before.
the basis, on that basis, right title or interest was declared in favor of the plaintiff.
Plaintiff.
So where is your case then?
Lordship, though gift deed was not proof according to the law. Gift deed was not proof according to the law. signatures was not exhibited in the gift deed. Only exhibit number was there only. No signature, nothing has been exhibited in the evidence.
So how a gift deed is to be proved?
That's it.
The question is how a gift deed is to be proved.
That's it.
What is the requirement?
Requirement, that's it. And apart from that,
Succession, in succession act, have you gone for the same?
apart from that, Lordship, the defendant said that the suit was also hit by the section 150. Suit is also hit by the section 154 of the Assam Land.
You see, there is a, rightly or wrongly, there is a gift deed.
Gift deed, Lordship.
And the said deed has not been challenged. Though you have challenged it, you could not establish the same by adducing any evidence.
Yes, we have not adduced evidence, Lordship. That is true.
Now the question is how the plaintiff has proved the gift deed before the trial court as well as the appellate court. And what is the requirement? Whether attesting witnesses have been examined?
No, Lordship. From
No.
record, I didn't find anything. Only exhibit might, even in judgment also, following documents, it was reflected in the judgment of the trial court, page 26, Lordship. Page 26, Lordship. This discussion and decision, Lordship. The PW1, Sunita Sukha in her evidence exhibited the following document: Exhibit 1, Exhibit 2, and Exhibit 3.
Maybe, but since it was a registered date, the presumption is available in its favor.
Lordship.
Unless rebutted by the defendant. Defendant not entered into the witness box.
This. Apart from that, Lordship, this suit is also hit by the section 154 Assam Land and Revenue Regulation 1886, 154, Lordship. Because his claim compensation is the mutation, Lordship.
Whether you have raised this issue before the first appellate court?
Of course, Lordship.
Where? Where is the memo of appeal? Is it part of the record?
Part of the, I didn't I'm not
Enclose it.
annex it, Lordship.
You annex it?
Lordship.
Because in second appeal, you cannot raise a plea that has not been taken before the courts below.
Lordship, in appellate court judgment, the ground has been mentioned, that page 43. Page 43.
Where it is mentioned?
There's nothing there, Lordship.
Not been reflected.
Not is reflected.
You bring on record the
Yes,
memo of appeal.
Lordship.
On next day, we will say. Part is the border subject or the reference. List the method on when.
After 1 week, Lordship.
After 1 week, and in the meantime, Mr. Bhattacharya shall bring on record the memo of appeal filed before the learned first appellate court in title appeal number 5 of 2018. List after 1 week.
Pending items 15 and 16.
Lordship, in item number 15, I am preparing on behalf of respondent number 4, P. Sharma.
Pardon?
In item number 15,
Yes.
I am appearing on behalf of P. Sharma for respondent number 4, Lordship. I have to file affidavit, Lordship. Kindly a 2 weeks, 1 week time may be given, Lordship. Today we will file our affidavit, but in the record of the
Okay, then. For item 5, we have already filed. It may be called to the record.
Why?
Is there
Earlier, Lordship, earlier already filed, Lordship, this he responded,
four
he did not in last
Yes.
two occasions sought for time. And today my friend is saying that they are going to file. Lordship, then this matter may be fixed on Friday, Lordship.
Yes.
As because my friend is showing this activity is ready. That today they are going to file.
We'll file today our affidavit, Lordship.
Okay. But Mr. I hope learned counsel for the petitioner. Mr. Gogoi for response, contender number 5. Contender number 5 and Mr.
R. Chetri.
R.
Chetri on behalf of P. Sharma, Lord.
Shetty, learned counsel appearing on behalf of Mr. P. Sharma. For
Contender
the respondent number
4.
Respondent number 4 and Madam Info.
Respondent number 2 on behalf of the question.
Respondent number
2,
2 and 1, 2, 3.
1, 2, 3.
1, 2, and 3.
Yes.
Appearing on behalf of Mr. B. Kosik. The learned counsel appearing for the respondent contender number 4 submits that during the course of the day, he will be filing the affidavit. In that view of the matter, SSL is the matter on Friday.
Can the matter be released on Monday, Your Honor? My senior will be not in a station.
Monday.
27.
Yes, go on.
Lordship, then if possible, Lordship 28, Lordship.
Pardon?
If possible, Lordship 28. As because Lordship on Monday I have some personal difficulties, Lordship. Lordship, then okay, Lordship. Okay, 27.
27.
I'll have this.
Number 44. Orders.
The collector have
Yes.
file amended.
I have filed amendment constituted, but Lordship, there is some objection from ST side regarding Lordship last order. Can you Lordship have the last order? Accordingly, Lordship, it is provided that it should have been Lordship, Mr. Sandeep Kumar.
Arvind Kumar.
Sandeep Kumar it should have been. Because the present incumbent is Sandeep Kumar.
Sandeep
So now they have also, they got confused, Lordship. So they called me to verify this.
Okay. Sandeep Kumar, okay.
Yes.
Heard Mr. Polita, learned counsel for the petitioner and Mr. I. Portaco for the contender. Mr. Polita submits that he has filed the amended cause title, but there is some objection on behalf of the registry as in the order dated 16/7/2026. The name of the contender has been reflected as Mr. Arvind Kumar. But in fact, the same ought to have been Mr. Sandeep Kumar.
Sandeep Kumar,
Sandeep
Principal Chief Conservator first.
Principal Chief Conservator of first. And accordingly, it is provided that the name of the contender in the order dated 16/7/2026 henceforth be read as Mr. Sandeep Kumar, Principal Chief Conservator of Forest and Forest Force of Assam. Mr. Colita shall accordingly file the amended cause title.
already I have
Rest is a
filed,
list the matter on.
already I have filed,
You
Lordship.
have filed.
Lordship.
When
Register
can
me,
we list the
Lordship,
matter?
only, register me, include the name of this Sandeep Kumar, Lordship.
No, let the, it is not available now.
They have received, Lordship. Yesterday I received a call from registry, Lordship. The registry called me to verify this line, Lordship, regarding this word Arvind Kumar instead of Lordship Sandeep Kumar.
Okay,
Lordship, they have
they will
received
not
my-
pass that order. Let it be placed on record.
Lordship.
We will consider the same. We'll list the matter on Wednesday then.
Lordship.
Wednesday.
Lordship.
Second. This is a list the matter on Wednesday.
As part of that one. As part of, Lordship.
Pardon?
As part of, Lordship.
As part?
As part heart. Otherwise
Okay,
it may go
part
to
heart.
another bench
Okay.
again.
Okay, as part heart. Okay. Okay.
Sorry. Oh, that's okay. So that you change.
Yes, Mr. Razo?
My lord, my lord, my learned friend, Mr. Raju and me both are appearing.
Yes.
Yesterday, while taking the briefing, my lord, I
Yes.
thought of some solutions, my lord. If the
Yes.
Honorable Court can consider having it on some other day, Lord, we may find a solution, my lord, which may be win-win for everyone.
Okay. Okay. How the solution is to be found out?
So, my lord, I'll have to discuss with quite a few people, my lord. It may not be proper on my part, my lord, right now to share it because it may not go through. But I'm quite hopeful of some positive outcome.
Okay. See, this matter is pending quite a long time.
I'm conscious of that. Your lordships have even said that this would be the no further adjournment. My lord, I have seen that order as well.
Yes. Mr. Das, any objection?
So if there is a solution, there is no, where is the question of my objecting, my lord?
Okay.
It is only what we are interested is the award which has been passed, that should be paid.
Okay.
Now it can be settled, no, nothing like that, my lord.
No,
Nothing like
settle,
that.
I would not say, I will say some solution is to be found.
Okay. Okay.
So only what is my only prayer before this court, your lordship has seen. So how this matter has taken up to which particular. So my only prayer before this court that if this particular, they said that no, they will have some discussion. So let it be as fast as possible so that your lordship can fix a date so that they can come up with a particular solution what they want to say before the court.
Okay. Okay. Can a date be suggested on your behalf?
My lord, if your lordship can keep it after 3 weeks, whatever, my lord, is in my mind, I'll try and, my lord, work out with others.
After 3 weeks.
3 weeks.
Instead of 3 weeks, can it be after 2 weeks?
Yes.
My lord, a week more may not make any difference.
Okay. That's
Well, I want to be fast as possible. If my learned friend they can do it as fast as possible, they can discuss the matter with the
okay.
authority concerned.
Okay.
So if it is be 2 weeks, it will be better, my lord. If
My lord,
it can be done.
I would rather, my lord, leave it to your lordship's discretion. I would request for 3 weeks, my lord.
Okay. If within 3 weeks we can find out a solution, then all right. We'll grant you 3 weeks time. Okay.
Can it be done like this, my lord? After 2 weeks, they can come up. The matter can come up before the court.
Mr. Das,
they
let
can,
the court monitor the proceedings. I
no, it's
understand.
absolutely. If
Yes.
that can be put forward before the court after 2 weeks also, whether the particular it can be worked or not, at least
My
that
lord,
can be.
if this, anyway, my lord, I don't want to.
It's my lord. This also I will.
I
This is
think
my
we will have to
anxious.
leave it to the court at some stage.
Yes.
Okay. Let it be, Mr. Das, let it be 3 weeks.
Yes.
After hearing learned Solicitor General of India and also the Additional Solicitor General of India and Mr. Das, learned counsel for the respondent, this matter is then adjourned to be taken up after 3 weeks. Let us fix it that
Yes, my lord.
My lord, I appear for the state, my lord.
Mr. Ratan for the state of Arunachal Pradesh.
August.
Obliged, your lordship.
Okay. At 2 p.m.
At 2 p.m.
Okay.
Please, sir.
Grateful, my lords.
At least my
Right.
lord will kindly note down that some solution or what they.
No, my lord, that is something said in good faith. They are not to be,
Okay, all right. All right.
please, your lordship.
Your lordship will speak.
Mr. Razo, there is one contempt petition is also on the date of reservation of the order. We have stated that we will dispose of this contempt petition along with the writ petition.
Yes.
So today the matter is listed under the head to be spoken, and we will hear both the matter again together.
The contempt petition I already argued and pointed out there is no
No,
contempt.
no, that's all right. That's all right. You have argued. Okay. Both
Yes,
the
sir.
matter will come up on 12th of August. Okay.
Please, sir.
August.
I am deeply obliged.
Highly obliged, my lord. Done.
Please, your lordship, I had made there was a misunderstanding. It's my bad. I said a couple
No,
of.
that's all right. Where is your case now?
They have sent them down. They have come. It's on the way.
On
Three
the
of-
way.
three items. I have some more which I'll do tomorrow, lordship. But three. All are same. On the way for the normal. Where's the file? Lordship, filing has become very difficult nowadays. I don't go, my juniors go. Filing has become very difficult nowadays.
Why?
There's a lot of process. It's not streamlined. That's the problem. Now at the last minute they want to say that we want to check whether there's a caveat, and then again the person who checks the caveat is not there. So again, these are the reasons why the filings are getting held up. I mean, there has to be a system, lordship. Someone who checks up in the computer and finds out whether caveat is there. I don't know.
But have you appraised the matter to the registry?
I think I will talk to the registry tomorrow, because my juniors have just told me now.
Yes.
So, and I'll talk to the clerk also, what are the problems they are facing. And I think I'll give the written thing to registry.
Yes.
Otherwise, it becomes very difficult.
Or you can report the matter to the Chief Justice also.
If necessary, I'll talk to the registry first, and then I think I'll talk. I think it will not be fair to go to the Chief Justice straight away. It's better to go talk to the registry, see out what the registrar can sort it out. Nothing like it. I mean, I can't imagine 3 files not coming, which was filed on Saturday. I mean, I don't like to keep your lordship waiting also. If your lordship wants to take it up tomorrow, I'll.
Tomorrow?
I mean, if lordship has to, is otherwise. I don't want to keep your lordship.
No problem. We'll sit again at 2:30. It is 2:15. After 15 minutes, we will try.
আপুনি তিনটা মোক লাগে কিন্তু কোনবাই মোক কৈছে যে ফাইলটো লৈ আহি আছে বুলি হা
Okay, let us try it. Madam, let us try at 2:30.
2:30 he can inform your lordship.
Okay.
Yes, lordship. Lordship, here I have come against the judgment of the district judge in under section 9 of the Unauthorized Premises Eviction of Illegal Occupants Act. Lordship, the judgment is at page annexure 12, page 94. So, lordship, I will not take too much of your lordship's time, but I'll take lordship straight away to the point of determination. Now, he has not applied his mind to all the relevant factors which has to be considered by him in a judgment.
Lordship will come to page 101. Whether the point of determination, whether the learned estate officer had rightly held that the land in question is a public premises within the definition provided under the Public Premises Eviction of Unauthorized Occupation Act, and thereby the appellants are liable to be evicted. Now, this is a single question point of determination which we held. Whereas under this act, a show cause notice under section 4 of the act is mandatory if I am an unauthorized premises. Here there are two factors, Lordship. Even in the
No, whether notice was not issued?
notice under section 4 was not issued.
Not issued.
Not issued. And moreover, we were not unauthorized occupants in the sense that I have a holding number, I have a license from the railways. And even if I have a license and the license is revoked, they are bound to issue a notice. So on this count itself, Lordship, this needs to be stated. Whether the learned judge has to determine whether notice has been served properly. What had happened, Lordship, a number of things were going on since 2014. And thereafter, we had come to the High Court a number of times. They sought to evict us. ADC had also issued us letter saying that these people will be evicted to deploy the magistrate and other stuff. That was in 2024. Then we came to to this honorable court. This honorable court quashed those letters, and thereafter said that you file a representation. We file a representation primarily on the ground that we are license holders. We have been occupying this land. Plus, we are paying holding fee to the Bokajan, to Karbi Anglong Town Committee. Another aspect is that this part of the land belongs to Jadav Rai grant land. That is what we say. And we were paying revenue to Jadav Rai under the grant also. So if the grant is the Karbi Anglong land, all these things we said. But the estate officers had no, it is a railway land. There's a certified plan under which we have been given this land and issued the eviction notice. Then we went under section 9. Now this is the reason where I have come now. Nothing, no show cause, nothing has been issued. That is mandatory, Lordship. You can't proceed without a show cause notice. Supreme Court has held whether I'm illegal, unauthorized, whatever, a show cause notice is a must.
Yes, anybody for the Union of India?
Lordship, Indian case is a claim appearing, Lordship. But here also, item 1, that copy we have not received. And this is item 2, but here only page 40. Lordship.
I'll just give you my copy.
Just receive the copy, Lordship.
Item 1.
Item 1.
Okay. All right. It's the same judgment, Lordship. Dicto, word to word is the same.
But instructions are left. Let the matter come up tomorrow, Lordship. And no, Lordship, cost of release and leaks in another court number 7, Lordship.
No, this is not item 42 is a correct case.
No, she's taking item number 2.
You're taking item number 2.
One we have not received. Only.
I know, but the judgment is the same. Dicto judgment. It will be judgment accurate. Accurate judgment. Same judgment, same. Because I fear, my Lordship, because my date was still today. Today they are bound to evict us.
So, Madam, all right, we will take up the matter tomorrow. But you inform the authority not to initiate any action against the appellant here, sorry, the petitioner hearing.
One day it won't affect, let tomorrow, right?
No, one day will not. He says you inform them not to take any action.
Till tomorrow.
Till
tomorrow.
But anyway, Lordship, they won't evict them today.
I mean,
but still now, no such.
No, it is their apprehension that they may be evicted. Heard, Madam, I'm making Learned Senior Counsel assisted by Mr. Learned Counsel for the petitioner, Ms. L. Devi. Learned Counsel appearing on behalf of Mr. A. Gogol. Learned Counsel for the Learned CGC for the respondent number 1. And Madam for Ms. D.D. Burman, Learned Additional Senior Government Advocate for the respondent number 4. And you, Miss, your name, please. For the respondent number 5. Respondent number 5. This petition under Article 220, under section 115, read with section 151 of the Code of Civil Procedure. Read with Article 227 of the Constitution of India is directed against the judgment an order dated 19/6/2026 passed by the Learned District Judge Karbi Anglong in title appeal number 2 of 2025.
2025.
Peruse the petition and the documents placed on record, and also peruse the impugned order dated 19/6/2026, and also the impugned eviction order dated 38/1/2025 passed by the state officer NFLA Lamding. Ms. Devi, Learned Counsel, apprised this court that Mr. K.K. Gogoi, Learned CGC, is in legs in another court, and as such, he placed for listing the matter tomorrow. Where allowed. However, it is provided that till tomorrow, the respondent authorities, especially respondent number 1, shall not initiate any
Eviction.
eviction. No, shall not eviction.
Shall
shall
not-
not
not
initiate the eviction procedure against the petitioner hearing. Please tomorrow. Yeah, same order in other.
Yes, Lord. Obliged, Lord. Tomorrow, I think it'll come in the supplementary. It has to.
Tomorrow?
No, tomorrow, like the day after, like
No.
Lordship, let it be till tomorrow, let the matter come up, Lordship.
Tomorrow?
Tomorrow, we are all right.